All right. So, good afternoon, everyone. We'll start with this session now. Today, we have Advocate Anuja Saxena, and she will be taking the session on drafting for civil and criminal pleadings. So, before starting with the session, I'll just like to give a brief introduction of our today's host. And our today's session is on drafting for civil and criminal pleadings, and it is going to be taken by Advocate Anuja Saxena. She is experienced advocate and legal advisor with the Rehabilitation Council of India, specializing in mediation and dispute resolution, serving as a national trainer with the Mediation and Conciliation Project Committee, Supreme Court of India, and as a training advisor at the Delhi Dispute Resolution Society. She is actively involved in promoting mediation practices across India, skilled in legal advisory, conflict resolution, and capacity building programs aimed at strengthening access to justice and alternative dispute mechanisms. So without further ado, we'll start with the session. I'm over to you.
Thank you, Dhruv. Thanks for my nice introduction. A very good afternoon to all the participants and the organizer. It's really my proud privilege to address this group of the Australian Intellect group. And I'm here to the topic assigned to me is to how to draft in civil and criminal matter. So first we will start with the civil matters and then we will reach to the criminal matter. Or I'm just sharing with all of you that it will be an hour journey we are doing together. And it will be learning on both sides. So I would request all of you to please switch on your video so that we could have a little bit of an interaction and eye contact right now. And I should be confirmed that all of you are here and all of you are listening. May I request all of you to please switch on your videos. At least we should have one eye-to-eye contact. So I think the topic is very important. No matter if you're not interested to switch on your videos, but my humble request to listen it carefully, because despite positive try to just justify this session, very important for all of us as an advocate. The point is this: what is our objective to do this LLB program? The objective, can anyone share with me what is your objective to do this and to undergo this LLB program? What is your objective? What is your desire after doing this LLB course?
Madam, earlier we wished to join judiciary, but as soon as the 3-year practice rule has come, now we are trying to join litigation.
Very nice, very nice. At least now somebody is responding to my query. So see, as a lawyer, our first objective, maybe we are focusing on to become a judicial officer, but even before becoming the judicial officer, we should be the person who is well aware about the legal proposition and for the right of the people who are our customer of justice delivery system. They are approaching to an advocate to plead on his behalf before the court and get the best remedy for him, isn't it? For the same, we are preparing ourselves mentally as well as legally. We are legally sound about the law. We are legally sound about how to pursue before the court. And once it's a matter of persuasion. So again, I've put a question across. On what legal maximum our system is based? Anyone can? What is the legal maximum on which our legal system is based?
Is it quid pro quo?
No.
Is it
Yes, Kumkum.
Is it audi alteram partem?
No. What is audi alteram partem is to giving the chance to the other to speak out, isn't it? Right? The court is giving a chance to the other party as well, and hearing thereafter, the matter will be resolved by the court, right? Or decided by the court. So audi alteram partem is something that, but I'm asking on which legal maximum our legal section system is based.
Adversarial system.
It's
There
adverse.
is a right, there is a remedy.
Very nice. And how we are just codifying it in a legal maxim?
Ma'am, it is just a remedium. It
Very
is
nice.
something like this.
Radhisha, I'm really very happy. You rightly answered. Where there is a right, there is a remedy. Sam learning, he has given the right answer, but it was an interpretation. But exact answer is ubi just habi remedium. Where there is a right, there is a remedy. So being lawyer, we should be perfect in what is the right involved. The parties are approaching to us, they're just narrating the facts of their problem. Right? In civil, we are talking about the civil matter as well as in criminal matter. Also, it will apply equally. So once a party is approaching to us, they are innocent. They are not knowing the law. We are knowing the law. So they are sharing their facts before us, and that our judicious mind and the legal mind, which is applying on the facts under which provision of law he is entitled to get the remedy. Obviously, if he is having the right, the appropriate remedy is available in the law, right? So find out that law, and then to that particular provision under which his matter will lie before the court. And then your art of pleading, how you will give the structure to those facts what the parties has shared with you. These are my facts, sir. Parties are innocent. They will start from anywhere. Correct? They can start. The incidents happened yesterday, even in civil matter. He is not sharing that the father was having 4 sons, 3 sisters. We are 4 brother, 3 sisters. He's saying, yesterday my mother asked me to get out from the house. She has no right to say me like this, because they are not the organizer of the facts. Then, as a lawyer, we have to collect the facts from the parties so that we can give a frame to it, to just produce before the court how they are entitled for such remedy. Right is there, remedy is there, facts are with us. Then how to give the shape to their prayer to plead before the court that he is entitled for this remedy. This we say parties are approaching to a legal system for justice. Correct? And we as a lawyer are the first person who are understanding their problem, and then we are just helping them out to reach to an appropriate remedy. Correct? So therefore, we should be clear about the way we have to draft. And prior to that, we have to prepare ourselves. When I joined my profession, my senior always asked me, just go to the court and just see the way the other lawyers are putting their matter before the court and learn. A day will come when you will not have the time to even read the book, read the provision. You should very acquainted about the provision of law. Immediately the parties will reach to you. They are not supposed, they will wait for your understanding the law. Facts they will narrate. Immediately your judicious mind or your legal mind should immediately work. For what remedy he is entitled, what right is there, what right has been infringed. This is you to decide whether this is the infringement of fundamental right or civil right, or there is some criminal remedies he is or she is entitled. Correct? So being lawyer, the first characteristic that you have to listen carefully the facts of the party. Then thereafter, you have to apply to which appropriate remedy he is or she is entitled. Second step. The first step is that make yourself competent enough. Immediate parties will approach you and your mind should immediately work. These are the facts and under which provision of law he is entitled to get the remedy. Second, listen them carefully. Their facts. Correct? Number 3, give the shape to their facts in a way that they are entitled for such and such remedy. Number 4, how to draft it. Correct? So our focus today is how to draft. And there are 2 types of matter, broadly, civil and criminal. No matter, there are so many other branches like we will say service matter, like public interest litigation, like writ petition, like many other types. Every kind of drafting is having the different shape, like commercial matter, like this IBM matter. They are having all different type of drafting skill are required for the same. But as far as today's topic is concerned, we are focusing on the civil and criminal drafting. So civil matter, if I would ask, what is your understanding about civil matter? And how we can approach to court? Or rather, my question will be, can for particular facts on such particular, we can approach to the criminal and civil court both sides? Can we move? Yes. For particular facts, can we go for both side remedy, civil and as well as criminal? Yes or no?
Yes, ma'am, we can.
Yes, yes, ma'am.
If the material facts involved, the civil as well as criminal act also, right? He is having the civil right, and that drawn with the interpret with the criminal act also. The criminal act on the part of the parties is liable to be or in the shape of FIR before police station or a criminal complaint before the court, and the other side is a civil remedy he is entitled. So for particular one matter, like in matrimonial matter, if you will see, these are the combo pack of civil and criminal many side, family courts matters, then 49406 matter, then 376 matter, 354, many types of FIR. So one parties, they are having various kind of, facts are same. Correct? They are sharing the facts. And then as a lawyer, we are applying our mind for what remedies is entitled. For the such and such facts or such and such controversy, we have to go to the criminal side. For such and such fact, for such and such, we have to reach to the civil remedy. Correct? So let us start. I'm just sharing my slides. We first start with about the civil matters. So for civil matter, what do you think? What is required? What is required in civil matters?
Madam, filing of suit will begin the proceedings.
Yeah, filing of suit. Filing
Yeah.
of suit will begin the proceeding, right?
Right, ma'am.
Filing of suit is the main question mark. What do you have to file? See, recently I have filed one application before the Honorable High Court for a prisoner for parole application. His daughter asked me, when we filed the application, why parole has not been granted? I said, the court issued notice to the other party because the innocent girl was not aware what is the procedure of the court. From them, as an innocent person, they think application filed, application should allow. But we, as a lawyer, we know what are the further procedure. The court will issue the notice to the other party. Court will give enough time to the other party to oppose the application. Then only court will grant the relief, right? So therefore, parties are not aware about the way the matter will go, the way they have to, give the shape to their problem. We as a lawyer are giving the shape to the problem of the parties so that we can pursue before the court. Okay, this is the reason. These are the fact. This remedy is entitled. These are the provision. But what we have to include in our drafting in civil matter, that is first important. So rightly we have mentioned to first file the plaint, right? To initiate, to institute the suit. Institution of suit is very important, which is well defined in our CPC. Civil Procedure Code well defined the way you have to proceed in your civil matter. Prepare the case, criminal drafting, civil drafting. These all are the important thing in civil and criminal. Criminal, you have to just cover what criminal provisions, what kind of criminal act offense has committed. Mens rea is important. Other factor, actus is important. But in civil proceeding, you have to show how his right was involved and how the same has not been granted to him, and therefore he is approaching to the court of law. First, I will start with the civil proceeding. Just a minute. So the question, the institution of the suit, institution of the case, draft or maintainability, how it is maintainable in the court of law, that is important. Material fact and executable relief. What is our understanding about material facts? What is material facts? Am I audible?
Ma'am, relevant facts. Yes, ma'am, you are audible loud and clear.
Mm-hmm. What are material facts?
Material fact means clear and concise facts which are relevant in any matter.
Yeah, material fact means relevant facts, right? This is we as a lawyer to just find out of, if you will permit the parties, they can narrate their problem for a month or for a year. Because so much of grief, so much of pain has developed in the mind and their, life. They are ready to share everyday problem. But we as a lawyer first have to filter what are the material facts? What facts are important to place before the court? Court is not there. And truly speaking, from my own experience, I'm sharing, no court will feel happy if you are making the bulky petition. Rather, it is difficult for a court to go through all these. Repetition of facts, not good. Why you are repeating the facts? Once you have defined the facts, there's no need to repeat that fact unless there is a connectivity with the other, material fact. So we have to find out what are the material facts. Here need not to define what kind of evidence you are just having with regard to the material friend, only material friend, and what executable relief, what relief you want that should be executed. I mean, he is entitled, she is entitled. The pleading must narrow the controversy and survive threshold objection. Correct? Civil pleading should state material fact, not evidence or argument. I think all of us are clear about it. We need not to define evidence. On the basis of this, it is established that it has happened so. No, only material facts necessary to constitute cause of action. See, the cause of action is very important to establish in civil proceeding. What is the cause of action? Why the matter is before the court? Why it is before the court? Why the parties are before the court for the same? Cause of action, and cause of action, unless you define the cause of action, you cannot just frame your case. Under which provision? This cause of action comes under which provision? Dates very important. On which date, cause of action arose? Parties, very important. The name of parties, the memo of parties are very important. First, the jurisdiction of the court, memo of parties, date and incidents, the transaction, any breach, any kind of the facts. Then you have to define later. Jurisdiction and limitation facts. The matter is within the limitation. If all of you are aware that limitation, we always say it's a substantive and procedural law. Otherwise, we define substantive law and procedural law. CPC is procedural law. CRPC is procedural law. IPC, yeah, BNSS or BNS, it's a substantive law. So substantive law define the these rights and the remedies. How we have to take those remedies, the procedures define. Correct? So CPC define under which section, under which order, under which rule the things will go. And the same, how to institute a suit, it's well defined in Order 6 of CPC. We'll go through the Order 6 CPC thoroughly. You will see what kind of material fact you have to incorporate and the way you have to have in your plant. Fact supporting interim relief. If you are filing an application for interim relief injunction, you have to have such type of fact supporting there's need of the interim relief. The property may be disposed of, the third party interest may be created, and the this type of plea we have to put before the court. If the interim relief will not be granted immediately, something will go against the petitioner or against the plaintiff. Facts needed for valuation and court fees. These are also important facts for which parties are not aware. If you're filing a partition suit, you should be well aware about the valuation of the property that you have to enclose. Against that valuation, how much fee the plant is required as per the Court Fee Act, that you have to incorporate as per the Court Fee Act. This much of the valuation of the suit property and this much of the court fee has been enacted. So like this, we are covering all material facts. Material facts are not those facts only the parties are sharing. We have to just see, most important, the jurisdiction. If suppose a matter of rupees, recovery of 5 crore rupees, which court we will proceed in? Delhi. All the participants belonging to Delhi or some other state?
We are from different states, ma'am.
Okay. So if you are having the pecuniary jurisdiction of your courts, because in Delhi, till 2 crores, our matters are going before the district court. More than 2 crores matters are going before the original jurisdiction of Delhi High Court will start from 2 crores onward. So therefore, many of the courts and many of the states are having the original jurisdiction from civil courts only. So if your jurisdiction in civil courts lie with any amount of the pecuniary jurisdiction, then there is no harm. You can just say that the court is having the jurisdiction because the matters are this. It's a recovery of money, or it's a breach of the contract, or it is something the breach of the agreement terms, something specific performance. These are all the civil suits for which you can just define that the court has having the jurisdiction. Correct? So jurisdiction. Then you have to first write down the name of the court, which court, then the title, parties A, party B. Then you have to write down which type of matter is this. This is the remedy asking, under which provision of law. You are not defining the law. See, for example, you need the permanent, temporary permanent injunction 39. So you are 39.2, application the so and so, and anytime you can just produce under read with section 151, because 151 CPC gives all the authority to the court, the inherent power of the court to take up the matter if it is within the permissible jurisdiction of the court. So 151 is a kind of which gives the booster to the thing. Okay, the court will not dismiss our matter. At least the court will consider if 151 is there. So like that, right? So jurisdiction, pecuniary jurisdiction, the territorial jurisdiction. Say for example, if something the property, the parties all belong to one state, but the property is lying somewhere else, then you should be clear about the jurisdiction of the where the property is lying. That the jurisdiction of that court you have to invoke, not the parties where parties are staying. For the same, you should have the very clear this thing, because you have to guide the parties. Right? Not evidence, full witness statement inside pleading, not required. Lengthy extract from documents, not required. Unnecessary case or summaries are not required. Speculative motives and moral commentary are not required. Every email, phone call, or negotiation, because you have enough time or stage for producing the evidence by way of affidavit and then the annexures. You have to make the annexures, you have to exhibit admission denial of the document. This is where after the completion of pleading, the first step is the admission denial. Drafting a standard, every paragraph should move the court towards one of five things. Number one, jurisdiction, cause of action, defense, proof, or release. Is that clear? Yes? Should I move to the next slide?
Yes, ma'am.
Yes. A civil suit should be triggered by cause, forum, limitation, parties, relief before drafting. What is cause of action? What legal right was violated and when did it arise? Correct? This is cause of action. In totality, in nutshell, what are the legal rights? How they are entitled for this legal right? If suppose you are filing the partition suit, property belongs to the father. Father has passed away on such and such date. Now they are in possession. They are just trying to dispose of the property. I have right in the property, being the son of my father, and father passed away. So cause of action arose on such and such date when they called some, this property dealer to sale of the property. Correct? So here the cause of action arose. That you have to define very nicely. The art of drafting is in around cause of action, because that directly give the remedy. For what remedy he is entitled if the cause of action is this. Cause paragraph, limitation paragraph. This is your drafting output. You can take the pick of the slide as well. Once you will go through these slides, I tried my level best, and I just requested some very professional person to make the slide in a way it will be useful for all of us for any time whenever we are having any kind of drafting and we want the clarity about the draft. Forum, which court has territorial, pecuniary, and subject jurisdiction? Very important.
Ma'am,
Yes, sir.
ma'am, your slide is not visible.
Slides are not visible.
No, ma'am.
Ma'am, it's actually visible. I guess.
Ma'am, it is visible.
Yeah,
Visible,
I guess
ma'am.
Pali and Radhesham are facing some issues with that. Guys, you can maybe rejoin or switch your devices. The slides are visible perfectly to other students.
Okay.
Okay, sir.
Radhesham, I really, I cannot help you because others I can well observe it. So therefore,
Ma'am,
there's
maybe if possible, you can share me the slide on WhatsApp right now. I'll share it to the group itself, so students can go through the slides simultaneously.
after completion of my session, because I have one more session at 3, then 4:30.
Okay. No worries, no worries.
So therefore, I am going speedily. There's a lot of things I have to share, and
Yes,
through you
yes,
always
yes.
give me very small time. It's very difficult to
Extremely
justify
sorry,
this
ma'am.
specific
Extremely
topic.
sorry. Yes, ma'am. You can continue.
Yeah. So the forum we have to define, jurisdiction paragraph we have to make out. Correct? That means to define the jurisdiction we have to make out how the jurisdiction of this court lie in this matter because of this, because the property lie within the permissible limit of this jurisdiction of this court, or the pecuniary jurisdiction of the court if your state is having the pecuniary jurisdiction. Who is necessary for effective adjudication? Who is only proper? Necessary party. Please go through. There's a special provision for necessary party, performer party. Necessary party, without necessary party, your suit will be dismissed at a time when it will come up with the. So therefore, once you are making the memo of parties and capacity pleading, okay, memo of parties, make the memo of parties that these are the necessary parties and these are the proper parties. Then relief. What relief you are begging for before the court? You are praying before the court. Declaration, injunction, recovery, position, specific performance, damages. These are civil nature type of dispute. Declaration and cancellation of document. Injunction, correct? To stay the other, to damage my property or to enter my property. Recovery of any amount which is pending out of some agreement or something, breach of contract. Possession, someone is in illegal position and this is a criminal trespass. This may be a bland question of criminal and civil as well. Specific performance, you want to that the such and such agreement where they specifically mentioned that should perform specifically. And damages. Layered prayer clause. Prayer clause should be layered. It should not be in paragraph form. Prayer 1, 2, 3, 4. Layered, not a paragraph. Correct? Be careful about the prayer clause. Because here you are praying on behalf of your party. A single mistake in your prayer will rule out totally, your plenary and pleadings. If prayer clause you have not incorporated some prayer, then therefore at the time of argument you cannot put before the court that this is my prayer. The court will where you have prayed for the same, and then everything will go. So prove which document proves each material facts. Only you have to maintain the document that it is annexure so and so. Don't produce over there. Don't place the facts available in the document in your pleading. Only just say that this document is annexure so and then you are giving annexure list evidence matrix. Correct? So annexure list, and if these annexure list as well as these the planned and your wakalatnama memo parties, for the same you have to have one index also. So once you will start your filing of the case, you have to have the index as well, and you're maintaining everything over there in the index. From this page to this page, this is my plan. From this page to this page, annexure list. This page to this page, this suppose it's SPA holder or GPA holder. GPA is lying from this page to this page. My wakalatnama is lying. So you are making the index as well. Interim risk, what irreparable harm occurs before final decree. So therefore, if you are pleading for the interim relief, that also you have to have separate application that this interim relief is much required, and application along with the urgency of the fact you have to incorporate in that application. And that should be separate from the plan. You cannot say it has been already mentioned in the plan that it is the earliest possible the disposal of the matter is required because so and so will harm the property. No. For the same, the interim relief required, you have to have the interim application separately. And day one, you can press for interim application. Then the court may or may not grant the interim relief, but court may put on some other day when the notice will serve to the other party. So therefore, this is a discretion of the court. But our duty is to place the interim application. A plaintiff should tell the court why it has jurisdiction, what happened, why relief follows, and what order is sought. So if we will go, this is a flow chart, court plus parties, forum, jurisdiction, capacity, address, and status. Cause facts, material facts, and chronology. Breach, injury, clarify, identify. Legal entitlement, right, obligation, violation, and relief link. Limitation, valuation, cause date, court fees, pecuniary jurisdiction, prayer plus interim. Correct? So I think it is clear यहाँ तक. So strong plan feature, what are the strong plan feature and what threshold vulnerabilities? So I'm not going strong plan feature. I have already discussed threshold vulnerabilities. No cause of action disclosed. If you are lacking in disclosing the cause of action, plan will be dismissed. Suit appear barred by law limitation. If you are not justifying that you are within the permissible limit, and all of you must be aware about it, because this again I'm saying substantive procedural law of limitation. Under section 5 you can go for the condonation of delay application. If you are suppose barred with the limitation, file one application of condonation of delay along with your plan. This is the discretion of the court to allow you and condone the delay. Necessary party omitted. If necessary party omitted, plaintiff will not bar. Plaintiff undervalued or wrong court fees paid, then again will not suffice the purpose. Relief vague, excessive, unsupported by facts. Correct? So these are threshold vulnerabilities. Now come to the one thing is this: you are filing the plan. The other side, you are filing the written statement. Now you are the counsel of opposite party. The opposite party is approaching to you along with the brand, along with the suit. Okay, sir, this is the case has been filed my brother against me, and I'm in possession of the property. And now he's asking that cancellation, declaration, cancellation of the document. I have purchased this property from my father, and these are the documents. Now you have to prepare the written statement. So both sides, you may be on the side of the plaintiff, you may be defending the your client as a respondent, as a defendant. So you should be prepared how to draft the written statement. So WS component, what are the WS component? Preliminary objection. This is the most important, head. Most important head, preliminary objection. What preliminary objection is something which you are narrating the facts. Facts and facts not like you are just narrating all the facts which are opposing the total plan pairwise. No. Pairwise reply you will give later. It is something what preliminary submission you want to put before the court. Ki why he or she is not entitled for such and such relief. So it should be attack jurisdiction, number one. If the jurisdiction of this court does not lie. Limitation. The suit is barred by time. Maintainability. It is not maintainable. If suppose 125 petition has been filed for the maintenance or DV, she is asking for maintenance. Your maintainability issue, she is earning. She is working as a teacher. She is an IT professional. She is a doctor. She is not entitled. So therefore, maintainability, you are making the objection. Valuation. The suit is not properly valued. And then parties. So and so is not the necessary party, or so necessary party has not been incorporated in the memo of the party. So you are taking the preliminary objection. What is drafting tie? Keep separate from merits, avoid repetition. Don't go with the merit of the case. You are just objecting preliminarily. That means without going into the merit of the, all the paragraphs of the plan, you're just making the submission that this suit and this petition is not maintainable because it is not fulfilling all these important ingredients. Pairwise reply. Then comes the pairwise reply. Admit, deny, or party admit with specific explanation. Be clear in your mind. If you will not specifically deny the facts, that will be considered as affirmation on your part. So unless you deny the facts, it will go against us. Don't leave any para unreplied. All paras should be replied properly. Correct? Or if there is repetition of the fact in many para in the plan, then you can cover the para 1 to 10 are taking these facts which are so and so, and I deny all together. So you are defining, and 1 to 10 para I am defining in this way, and I am denying the facts. So please don't let the affirmative part on your part. So therefore you have to deny specifically. Vague denial weakens defense. Correct? Vague denial. Don't do the vague denial. Denial should be specific. So be focused. Not a single para should remain unanswered. Positive defense, set out defense, own material facts. You must be having the fair. See, facts you are gathering from the parties. Again, I'm saying. So collect the facts from the party. Ask them to sit with you once you are giving a shape to the written statement. Because later they will say, sir, I have shared this thing with you. You have not mentioned this. No, sir, sit with me, read it. This is my own practice. Whenever I'm giving the dictation, I'm just asking them to sit here and listen your facts. Because we are not aware about the facts. These are the parties who are sharing the facts. Correct? And then many times it will happen. You see, as a lawyer, our duty is to do the articulation as well as give the shape to the petition and to the written statement. And many times we are twisting with the facts. This again your art of advocacy. How you are twisting the facts so that we can take much in favor of our parties. Do not hide defense only in denial. Right? Only saying no, I deny. Give the specific reason of denial. Set off counterclaim, claim independent relief where legally maintainable. If you have to set up some counterclaim, then also you can just put forward, you can file a separate claim independent. Check limitation and value of the setup for the counterclaim. Document disclose, rely document and adverse document where required. Maintain document index consistency. like they are producing the evidence, similarly we are also producing as a written statement document, then give the document index, consistency, and the proper manner. You have to enclose the document. Parties are not aware. Either way, they have to enclose the documents. Interim injunction drafting must establish urgency, legal right, and repel harm in tight sequence. If you are asking for the interim relief, prima facie you have to make the case. Injunction is required immediately. Why it is required? Right ascertain right legal rights, material for supporting breach threat, document showing entitlement, why the claim is not speculative, why the court has power to intervene. See, in every matter, almost in every matter, civil matter, there is need of the interim relief, because parties always suggest us, okay, sir, if we will not get this remedy, because we know civil matter will go for years, and by the time anything may happen with the any kind of civil document or the property or recovery, whatever the kind of matter is, if it is required the interim relief, but this is what you have to say, because we have to convince the court, and lawyers are always considered as the officer of court. Be honest in your work and be honest with the court. This is my practice. I never ever speak lie, though there's no question of speak lie. If the parties are even submitting, ma'am, this is the no, give me the clarity. I'm a lawyer, I'm not a liar. I can't speak wrong. So maybe if you have some kind of document, if you have some proof, then only I go to the court. And many times it happens because of the lack of document available with the parties. They are, despite they are having the entitlement, but they are not getting the relief. But our problem is this: we cannot pursue the court orally, and court cannot grant the relief or on oral submission. The need of the evidence. Correct. So first our facts, then evidence, and then the arguments. Balance of convenience, that we have to define. What is the balance of convenience? Comparative harm to plaintiff versus defendant. So whose balance of convenience lies in favor of our client, that we have to establish. Whether defendant can be compensated later, that we have to define. It cannot be compensated if the things will happen in this manner, any kind of harm will happen. Whether order preserve status quo, correct? Whether plaintiff approach promptly, whether undertaking is appropriate. Irreparable injury, harm not adequately compensated by damages. This is how we are just convincing the court. You see, interim relief is much required. Risk of alienation, demolition, disclosure, loss of position, goodwill, confidentiality or status, need for limited proportionate order, prayer with duration and scope. And then for the same, our plan should be so sound that court can rely upon, yes, the plaintiff is entitled for the prayer. And obviously, taking the total trial will take the time. So therefore, he is entitled for the interim relief. Different civil causes need different drafting emphasis. So a suit type, what suits requires? Recovery suit, money suit, debt, due date, the date of the debt, if it's a recovery or money suit, acknowledgement. The same was acknowledged. And you must be knowing that the limitation of any money suit or recovery will calculate from the acknowledgement. Otherwise, a 3-year limitation. But if he has acknowledged, okay, I will make the payment, very soon I will make the payment. This much is the acknowledgement, and our calculation, our limitation will start from the date of the acknowledgement. So be careful whenever you're guiding your client going for the recovery suit. What is the date of the debt, or is there any further transaction between them, or any kind of this communication between them, which is establishing the acknowledgement on the part of the defendant. Interest basis limitation, typical document, invoices, ledger, bank statement, notice. So I hope and believe this is clear to all of you. This is recovery and money suit. What is required? Drafting emphasis, and what typical documents are required? These are those. Property, title chain, possession history, identity of property, encroachment or threat. Correct? So these are drafting emphasis. And what typical document are required? Sale deed, revenue record, site plan, photos. Please don't put that he is paying the house tax, therefore he is entitled. House tax is not the proof of the ownership. Mutation is not the proof of ownership. For the same, you go through the conveyance deed, etc. What are required? What you have to show to the court? Just showing that he's paying the house tax, therefore he is having the ownership right. No. Some more documents are required. So sale deed, revenue record, site plan, photos, specific performance, contract readiness, willingness, breach timeline, and consideration. agreement received correspondence notices, specific for ones. One has, they have a contract between A and B to purchase so and so shop. And now after taking 20 lakh rupees, he's not transferring the property in his favor. He is ready to make the rest payment. The other party will come up, the timeline for making the payment was 10th of May. He has not paid the money. So therefore, the same was not specifically performed. So now he has no right. The amount is forfeited as per the term of agreement. So both sides are putting before the court for their best relief. Correct? So be prepared. What argument you are putting before the court for your client as a plaintiff, and what argument you have to before the court if you are contesting from the side of the defendant. Declaration, injunction, legal character, right, threat, necessity of declaration, title, status document, threat proof, notices. These are the typical documents which are required. Commercial dispute, pre-institution step. If all of you are clear about it, now Commercial Court Act is there. And before institution of any commercial dispute, you have to have the pre-litigation mediation, which is under Section 12A is defined. The Act was amended in 2015, and now 12A was incorporated. So before pre-institution step means whether you have stepped in for the mediation or not. It may successful, may not successful, but you have to start before initiation of any the suit, this commercial suit, need to take the pre-litigation mediation first. Contract, broad authority, email statement of truth. Now come to commercial litigation. Reward front loaded document, admission denial. These are the for commercial drafting. Authority to sue, board resolution, authorization, POA. Very important. First, who will initiate the commercial dispute, he must have the authority to sue. Specified value, document list, contextual clauses, qualification. Okay? So this you have to have na commercial drafting. Common commercial gap क्या होता है? Relief claimed without computation or contextual basis. You have claimed the relief, but you have no computation. The contextual basis, you have not calculated the amount. Ignoring arbitration clause or exclusive jurisdiction clause. Now, those were the days when the parties were having the arbitration clause. Now they are having the mediation clause as well. And the Act itself permitted to go for the pre-litigation mediation. So that also, you have to just specify the court that the parties have approached to the pre-litigation mediation before legal service authority, and the same was unsuccessfully. It was unsuccessful despite the mediator's or her efforts, but it was unsuccessful. Therefore, the petition before the court. Weak authority document for companies partnership. Again, no clear position or admission correspondence, overlooking email trail and electronic evidence clarification. See, there's need of the clarification to make the value to the email or any kind of electronic evidence you are generating before the court. You have to have the proof that the same was sent by the opposite party. Civil rights we should be planned backward from issues and evidence. See, so go back. Start with what kind of prayer will be there in this. The moment you are listening the party, you are just preparing in your mind what are the facts. What will be the admissible fact? What could be the issues framed by the court? What type of evidence are required? And how I will proceed before the court? Arguments. So go backward. These are the arguments, then what evidence are required, then what issues will frame, what admission is required, and what kind of pleading I have to prepare. Isn't it? So drafting implication, evidence implication, argument implication. Correct? Is that clear? Is that clear?
Yes, ma'am.
Yes, ma'am.
Thank you so much. So civil relief should be drafted with execution in mind from day one. Yes or no? We are working for execution, or we are just taking the paper degree for the parties?
Working for execution.
So working for execution, the same should be executed. So the relief should be executable. Isn't it? Exact amount, interest rate, start date, and future interest basis. This is what you have to define in your plan. Property description, boundary, survey number, site plan reference. Be careful whenever you are filing any property matter. Site plan is very important. Demarcation of property is very important. Description of property is very important. Time period for compliance and consequence of default. Again, very important that you have to incorporate. Direction for position, removal, handover, police aid or commissioner where needed. Cost and incidental relief. Correct? Avoid period that are two-way for decree drafting. See, one of the reason of pendency of the matter, the many of the plans, many of the petitions are not having clarity about the facts and actually what they actually want from the court, under which provision they lie, under which provision they are asking for the relief, and what kind of relief. The relief should be like, this is the mango and I want to eat this mango. It should not be like this, ki there is a field, they will doing working upon this, ki how the mango can be grown and then how we can eat the mango. This type of, don't make the false story type of this in drafting. It should be very realistic and what required in fact. Wider than factual pleading, dependent on future negotiation between parties, unclear on who must do what and by when, silent on interest, cost of enforcement mechanism where relevant. Okay. So a decree that cannot be executed is often a draft simple. Use the civil drafting checklist. This is the checklist. And written statement and interim application. Court parties' capacity are correctly described. Jurisdiction facts are clearly pleaded. Number 2. Number 3, limitation date and cause of action are expressly addressed. Number 4, material facts are pleaded without necessary evidence. Are you clear about material facts on this facts? No. Okay, again, let me recall it. Each defendant's role, liabilities identified, valuation and court fee basis checked, necessary party and statutory notice verified, documents are annexed and referenced consistently, interim relief test is factually supported, prayer clauses specific, layered and executed. So this is your checklist for any kind of plan, written statement and interim application. Clear? Is that clear?
Yes, ma'am.
Think it will help you? You can just prepare this checklist whenever you are drafting. You just go through whether you have mentioned the code, parties, and capacity are correctly described, whether you have checked the jurisdiction facts are clearly pleaded. This code have the jurisdiction, limitation date, and cause of action are expressly addressed. The same happened on such and such day, and cause of action arose on such and such day, and it is lied within the limitation of this limitation prescribed limitation act and within the permissible jurisdiction of this honorable court. This is defined. Material facts are pleaded without unnecessary evidence. Please don't add evidence with material fact. Correct? With material facts, don't include unnecessary evidence. You are just floating all the evidence with this. Is defendant role liabilities identified? If there are 3, 4, 5 defendants, you have to define their liability. You cannot skip the liability of any one of them. Otherwise, the court will ask why he is an accessory party. What for you are seeking the relief from this? Correct? So, if you are seeking a relief, suppose very recently one DVA matter has been filed. The client who approached me, I saw there's no any kind of allegation against her. So I said, what allegation against you? She said, no, ma'am, I was not staying with them. I am very far from their place. I don't know why she has incorporated my name. So it's something happened once a lawyer is not giving the total attention towards the facts of the parties, who is saying that who is narrating the facts and just narrating the number of member of the family, and the lawyer has just mentioned the name of all the members. Once you're honest with the court, you definitely mention the name of those party against whom you are alleging. Correct? So need to just to identify the liability of each defendant, valuation court fee, necessary parties statute notice verified, documents are annexed and referenced consistently, interim relief test is factually supported, prayer clauses specific, layered and executable. Most civil drafting failure arises from weak cause of action, vague relief, or poor document discipline. Cause of action missing, big failure. Where is the legal right? If you yourself is not clear what right you are just seeking for the parties, then what kind of prayer you are making before the court? You are not aware of the legal right. Correct? So cause of action missing, very important. Evidence inside pleading. You are mentioning the evidence inside the pleading. You're giving it all the detail. Pleading become argumentative and loses clarity. They are separate provision for evidence. Then what is the need to just mention the evidence over here? You can just to give the more beauty to your plant or to your defense, you can incorporate some case laws, but that to the reference for the reference purpose. In such and such matter it happens, so the similar facts are involved in this matter. Need not to define what had happened in this matter. Just make your pleading bulky. Okay, I should have the plant of 200 pages, then the other party will be in chaos. Many of the petition I have seen, and I am giving the reply 1 to 10 para are incorporating the same facts, and therefore need not reply separately. These are the facts. So what is the fun in unnecessarily wasting your time, money, and the pages, papers, above all the papers? We are just spoiling our forest, just making the this paper book. And unnecessary paper book, there's no need. Unnecessary enclosing the bare acts. I have seen so many senior, with all due regard to them, designated senior, what they are doing, they're making the file bulky. They are enclosing all the bare acts, like for so and so act, so and so act, complete set of that. The courts are there, the courts are having all the bare acts with them. At a single, their instruction, the any kind of act will be produced before them in the court scenario only, court proceedings only. So what is the need to just make the all the bare acts as the part of the pleading? So this is the wrong practice, what I suggest. So don't do that. You have to give the beauty to your client. That is the ultimate as a lawyer for all of us. Prayer asks for the review not supported by factor statute, territorial pecuniary jurisdiction, annexure confusion. Maybe there's some annexure confusion. You're not properly giving the number to the annexures. Be care and be clear. If you are having one document having 10 pages, define all those pages and then define the index. This document from 1 to 10. This document is lying on place number because entire paper book you're creating. Give the numbering proper. Weak paragraph, improved paragraph. This again. The defendant, this is a kind of exercise for all of us. Just go through the material fact. What weak paragraph is saying? The defendant has illegally and maliciously tried to grab the plaintiff's property and has caused great mental agony. The defendant is a habitual offender and is acting with bad intention. The plaintiff is entitled to justice. This is very weak para. No clarity about anything. Now, what is the improved para? The plaintiff is the recorded owner of property bearing. Here you are giving the description of the property. Bearing number so and so, house number so and so. On date, the defendant entered the eastern portion showed in red in side plan and began raising a boundary wall. This is what you see in the annexure. You have enclosed the side plan and enter. The plaintiff objected and served notice dated so and so, but the defendant continued construction of this. So, contents shared by the parties are seen. The drafting make it how to emphasize, how to just press before the court, the way the court will have a clear picture about the prayer, about the cause of action, about the jurisdiction. Correct? So this is the difference between a weak paragraph we are making and an improved paragraph or good paragraph. So what is our takeaway? The improved paragraph will give title, property identity, specific act, date, notice, and continuing fact. It supports injunction claims. Correct? So here we can support why injunction is required, because the same is continuing. The cause of action is still going on. So therefore, to immediate need of the stop the cause of action. Otherwise, it will claim irreparable loss to the plaintiff. This is a skeleton document messages for criminal. This thing I'm just going back to the criminal. This was all about the civil proceedings. I hope and believe all of you are clear.
Yes, ma'am.
Okay.
Yes, ma'am.
So now we have only all the other 3 minutes time. By 3, my next session will start. But I will try to just give you some idea about criminal drafting as well, because Dhruv asked me to give something about criminal law also. So what criminal drafting is different because liberty, stigma, and state power are immediately engaged. Here, because many of the matter, the state is...
Ma'am, sorry to interrupt, but if you have the next session, maybe we can take the criminal part in the next weekend.
Oh,
That's-
that's so kind of you. So kind
Yes,
of you.
that's
In fact,
comfortable.
I'm
with
having a
us.
session by 3.
Yeah,
I told you, na?
definitely. Because the civil part took almost an hour, so criminal will also take an hour. So we can take
Yes.
it next weekend.
It will be difficult. So next time will be the best time, isn't
Yes,
it?
ma'am. Definitely. Actually, all the students,
Yes,
ma'am,
ma'am.
had some plans made by their kids for the Mother's Day, and she
Ah.
asked me if we can reschedule the session, but we
No,
had.
even I requested you the same.
Yes,
I told you,
so ma'am has actually taken out the plan so that she can conduct this session. So we are super grateful to ma'am for conducting this session today on the eve of
It's my
Mother's Day.
pleasure.
And I'm
Thank
super
you,
grateful
ma'am.
to all the students. Super grateful to ma'am for taking today's session.
Thank you so much and
Ma'am,
happy
thank you,
Mother's
ma'am.
Day to all.
So grateful.
Happy Mother's Day to you, ma'am.
Happy
And thank
Mother's Day.
Insightful
God
session, ma'am.
bless you all. And all of you will become very good lawyer. I hope and believe see you all as our family in the court. Anytime you feel any problem, you can just approach to me directly or through Dhruv, you can ask. Right?
Yeah.
Thank you so much, Dhruv, for giving me this opportunity.
Yes, ma'am, definitely. Ma'am, you can just
Thank
share
you,
the
ma'am.
PPT or share it among students.
Sorry, I couldn't get.
Ma'am, you can share the PPT later. I'll share it among the
Yeah,
students.
definitely. I
Okay.
wish.
Thank you, ma'am. Thank you everyone for attending today's session. Thank you.